The Senate will come to order. We are on the second agenda, order of business 8, waivers and exemptions.
Oops. Notice of exemption, April 20th, 2021. The Fiscal Analysis Division, pursuant to Joint Standard Rule 14.6, has determined the eligibility for exemption of Senate Bill 235, signed Wayne Thorley, Fiscal Analysis Division. End of notices.
Thank you. Order of business 9, motions, resolutions, and notices. Senator Scheibel.
Thank you, President. I move that we take Senate Bill number 62 from the Secretary's desk and place it on general file for this agenda.
Thank you. You have heard the motion. All those in favor signify by saying yea. Opposed, nay. Motion carries. Senator Kiefer.
Thank you, Madam President. I move to take Senate Bill 269 from the Secretary's desk and place it on general file for this agenda.
Thank you. You have heard the motion. All those in favor signify by saying yea. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Madam President. I move to take Senate Bill 57 from its place on the Secretary's desk and place it at the bottom of general file for this agenda.
Thank you. You have heard the motion. All those in favor signify by saying yea. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Madam President. I move to take Senate Bill 314 from its place on general file and place it on the Secretary's desk.
Thank you. You have heard the motion. All those in favor signify by saying yea. Opposed, nay. Motion carries. Senator Spearman.
Thank you, Madam President. The amendment 407 to Senate Bill 44 has been withdrawn.
Thank you.
And that concludes order of business number 9.
Thank you. Order of business 13, third reading, general file.
Senate Bill number 44, introduced by Senate Committee on Commerce and Labor, revises provisions governing behavioral health professionals. People of the State of Nevada, represented in the Senate Assembly, do enact as follows. Section 1 of Section 1.
Thank you. Are there any amendments to the bill as a whole?
There are none. Section 34, subsection 2, end of bill. This bill requires a 2/3 majority vote.
Thank you. Remarks from the floor. Senator Spearman.
Thank you, Madam President. Senate Bill 44 revises provisions concerning the administration and licensure of certain behavioral health professions. The bill requires certain behavioral health licensing boards to issue a license by endorsement or a temporary provisional license to an applicant who meets certain requirements. The bill authorizes the behavioral health boards to adopt by regulation provisions to authorize remote supervision of behavioral health interns, reduce the cost for renewing a license under certain circumstances, and prescribe a list of crimes that would disqualify a person from obtaining a license from the regulatory body. In addition, the bill makes various changes to the Board of Examiners for social workers, including authorizing the board to issue a license as a master social worker to an applicant who possesses a master's or doctoral degree in social work and meets certain other requirements, authorizing a master and independent social worker to engage in clinical social work as a part of an approved internship program, authorizing the board to issue a license to an applicant who has graduated from a foreign college or university if the applicant submits certain documentation and meets other licensure requirements, authorizing the board to refuse to issue a license if an applicant has committed an act that constitutes grounds for initiating disciplinary action or entered certain pleas or been convicted of a crime that demonstrates an applicant's unfitness to engage in social work, and making it a misdemeanor to practice as a social worker unless appropriately licensed. The bill is effective upon passage and approval for the purposes of adopting regulations and performing preparatory administrative tasks, and on July 1, 2021, for all other purposes.
Thank you. Further remarks? All right, hearing none, the Secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the Secretary will close the roll. The vote on SB 44 is 21 in favor, 0 against. The bill, having received a 2/3 majority, is declared passed. Order the Assembly.
Senate Bill number 62, introduced by Senate Committee on Judiciary, revises provisions relating to solicitation of contributions. The people of the State of Nevada, represented in the Senate Assembly, do enact as follows. Section 1 of Section 1.
Thank you. Are there any amendments to the bill?
I have amendment number 467, proposed by the Senate Committee by Senator Scheibel.
Thank you. Senator Scheibel.
Thank you, President. I move that we dispense with the reading of the amendment.
Thank you. If there are no objections, so ordered. Senator Scheibel.
I move that we adopt Amendment 467 to Senate Bill 62.
Thank you. You've heard the motion. Are there any remarks? Senator Scheibel.
Thank you, President. Amendment 467. I'm sorry? No, there are no remarks.
Amendment 467 to SB 62.
62, yes, I would like to remark on its brilliance and necessity that it be adopted because it makes a clarifying change in Section 2 in response to some questions from members of this esteemed body regarding the definition of a contribution.
Thank you for the remarks. All right, hearing none. All those in favor signify by saying yea. Opposed, nay. Motion's carried. Are there any further amendments to the bill?
There are none.
Thank you. Bill, ready for final action.
Senate Bill number 62, introduced by Senate Committee on Judiciary, revises provisions relating to solicitation of contributions. People State of Nevada, represented in the Senate and Assembly, do enact as follows: Section 1 through Section 9. End of bill.
Thank you. Are there any remarks? Senator Scheibel? No? Senator Scheibel? Senator Canizaro?
Thank you, Madam President. Senate Bill 62 expands the types of organizations that must register with the Secretary of State as charitable organizations. Those entities that now must register with the Secretary of State as charitable organizations include entities established for any benevolent, philanthropic, patriotic, educational, humane, scientific, public health, environment, conservation, civic, or other eleemosynary purpose, which is a word that I'm going to learn how to say better. Entities established for the benefit of law enforcement, firefighting, or public safety personnel, and entities that employ a charitable appeal or reason in soliciting contributions. The bill makes several technical changes to reflect that these entities may not be required to register as tax-exempt organizations with the Internal Revenue Service or be organized as entities that file with the Secretary of State. Similarly, the bill revises information required to be disclosed in solicitations made by these organizations and makes them subject to laws governing deceptive trade practices. And finally, this bill is effective on October 1st, 2021.
Thank you. Further remarks? All right, hearing none, the Secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, Secretary will close the roll. The vote on SB 62 is 18 in favor, 3 against. The bill, having received a constitutional majority, is declared passed. Order the Assembly.
Senate Bill number 184, introduced by Senator Hardy, revises provisions relating to practice of medicine. The people of the State of Nevada, represented in the Senate and Assembly, do enact as follows: Section 1 of Section 1.
Thank you. Are there any amendments to the bill?
There are none. Section 47, subsection 2. End of bill.
Thank you. Senator Hardy.
Thank you, Madam President. Senate Bill 184
Did you want to
authorizes.
dispense with the reading of the amendment, Senator Hardy?
There's no amendment that I know of.
Oh, sorry. My fault. Go ahead.
So this particular bill authorizes the Board of Medical Examiners and the State Board of Osteopathic Medicine to issue a license to certain applicants who completed 2 or 3 years of postgraduate residency training and received a medical degree from a medical school in the United States or from a foreign medical school as applicable. The bill allows these medical boards to issue a special volunteer medical license to such applicants and exempts these applicants from the general requirements for licensure as a physician. In addition, the bill exempts an applicant for a license to practice medicine who has completed 3 years of postgraduate residency training and graduated from a foreign medical school from the requirement that the graduate must have passed the examination given by the Educational Commission for Foreign Medical Graduates. In addition, the bill makes various changes to licensure, regulation, and supervision of physician assistants, otherwise known as PAs, by the Board of Medical Examiners and the State Board of Osteopathic Medicine, including prohibiting the boards from requiring that a PA receive or maintain certification by the National Commission on Certification of Physician Assistants to satisfy any continuing education requirements for the renewal of a license. Also providing that provisions governing allopathic and osteopathic medicine do not apply to the performance of a medical student enrolled in an accredited medical program or a PA performing his or her official duties as part of any division or department of the U.S. unless licensure by a state is required. Also establishing provisions for a PA to obtain a simultaneous license from the licensing boards of allopathic and osteopathic medicine and requires the fees for a simultaneous license to be half the fee each board would charge for a person licensed by only one board, and removing the requirement of the Board of Medical Examiners to adopt some regulations relating to the supervision of a PA. Takes effect upon passage, and then preparatory regulations January 1st, 2022.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 184 is 21 in favor, 0 against. Bill having received a constitutional majority is declared passed. Order of the Assembly.
Senate Bill number 218, introduced by Senator Reddy, makes various changes relating to property. The people of the state of Nevada represented in the Senate and Assembly do enact as follows. Section 1 to Section 1.
Thank you. Are there any amendments to the bill as a whole?
There are none. Section 27, this act becomes effective upon passage and approval. End of bill.
Thank you. Remarks from the floor. Senator Ratty.
Thank you, President. Senate Bill 218 revises provisions relating to residential rental property and landlord and tenant responsibilities. The bill establishes independent definitions of security deposit and cleaning deposit and revises how each is to be handled upon the initiation and termination of tenancy. A security deposit may be applied for cleaning only if the unit is financed by a governmental agency and no cleaning deposit was charged. A landlord may claim the cleaning deposit, but no other amounts for cleaning, and a landlord must provide an itemized accounting of a security deposit and return the remainder no later than 28 days after termination. Failure to do so results in liability for the entire deposit and waives any claim to the deposit. The time within which a landlord may commence an action against a tenant for damages is extended from 6 months to 8 months, and the time allowed for the return of a security deposit is shortened from 30 days to 28 days. A tenant may file a complaint for expedited relief for the return of a security deposit. A landlord may only charge a rental fee application for one prospective tenant or group of co-tenants for one available unit at a time, and the fee must not exceed actual costs, excluding personnel time and administrative costs. The agreed-upon rental amount must be printed clearly along with a summary of fees, fines, and costs on the first page of any lease agreement, and disclosed prior to the signing of the agreement or the commencement of tenancy. Such fees cannot be increased without appropriate written notice. Rental agreements may not impose any fee, fine, or cost that is not expressly authorized in statute, and a grace period must be included in rental contracts for late rental payments, and no late fee may be charged until the grace period expires. An agent of an attorney may not be a property manager, and a change in property management necessitates notice to tenants within 7 business days that deposits have been transferred and no new deposits are required. Finally, a rental agreement entered into before this bill becomes effective is binding, regardless of the provisions of this bill.
Thank you. Further remarks? Senator Settlemeyer.
Thank you, Madam President. I had some concerns with Senate Bill 218. We'll be voting no today. The concept of the 14-day inspection period, and from the period of inspection, even though the person, the tenant, is in 100% sole custody, per se, of the apartment, it is assumed then that the damage was caused by the landlord, and I just had problems with that concept and could not support it. Thank you.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 218 is 12 in favor, 9 against. The bill having received a constitutional majority is declared passed. Order of the Assembly.
Senate Bill number 235, introduced by Senator Harris, revises provisions relating to cannabis. The people of the state of Nevada represented in the Senate and Assembly do enact as follows. Section 1 to Section 1.
Thank you. Are there any amendments to the bill?
I have amendment number 389, proposed by Senate Committee on Revenue and Economic Development.
Thank you.
Thank you, Madam President. I move to dispense with the
Senator Neal. Yeah.
Thank you, Madam President. I move to dispense with the reading of amendment number 389.
Thank you. If there are no objections, so ordered. Senator Neal.
I move that the Senate adopt amendment number 389 to Senate Bill 235.
Thank you. You have heard the motion. Are there any remarks? Senator Neal.
Amendment number 389 makes the following changes to the bill. Sections 1, 3, and 5 are deleted, and the provisions are established to allow the Cannabis Compliance Board to deem each adult-use cannabis establishment to be a dual licensee and authorizes the establishment to engage in the activities relating to the medical use of cannabis to the same extent as if the adult use cannabis establishment held a medical cannabis license of the same type. 2, a person who holds a medical cannabis establishment license on January 1st, 2022, upon the expiration of the license, is authorized to submit an application to CCB for the issuance of an adult-use cannabis establishment license of the same type, and the provisions are established to require CCB to conduct a study of the market for cannabis and cannabis products not later than February 1st, 2023.
Thank you. Further remarks, Senator Orenshall.
Thank you, President. You knew it was coming. I would like to once again disclose to this honorable body that my beloved wife serves as a member of the Nevada Cannabis Compliance Board, and because Senate Bill 235 greatly affects that board, I am hereby making this disclosure for the purposes of Senate Standing Rule 23, and I will be abstaining from voting on Senate Bill 235 and on the proposed amendment today.
Thank you. Further remarks? All right, hearing none. All those in favor signify by saying yea. Opposed, nay. Motion carried. Are there any further amendments to the bill?
There are none.
Thank you. Senator Brooks.
Thank you, Madam President. I move that we re-refer Senate Bill 235 to Finance Committee.
Thank you. You have heard the motion. All those in favor signify by saying yea. Opposed, nay. Motion carries.
Senate Bill number 263, introduced by Senator Settlemyre, revises provisions relating to elections of people of the state of Nevada represented in the Senate and Assembly do enact as follows. Section 1 of Section 1.
Thank you. Are there any amendments to the bill?
There are none. Section 6, subsection 2, end of bill.
Thank you. Remarks from the floor. Senator Settlemyre.
Thank you, Madam President. Senate Bill 263 eliminates the requirement to cancel a person's voter registration when that person requests to change their political party affiliation. The bill allows such a change to occur without having to complete a full re-registration of that voter. The measure also allows for overseas voters, or so-called uniform service voters, of his or her spouse or dependent, also known as covered voters, who is not registered to use the electronic equivalent of the federal postcard application to simultaneously apply to and register to vote and submit a military overseas ballot under the same deadline set forth for a non-covered voter using an absentee ballot. If a covered voter is already registered to vote, he or she may apply for a military overseas ballot via a federal postcard application or its electronic equivalent. If it is received by the 7th day before the election, finally, a covered voter may simultaneously apply to register to vote and request a military overseas ballot by submitting the federal postcard or its electronic equivalent by the 7th day before the election. The measure is effective upon passage and approval for purposes of adopting regulations and performing other preparatory administrative tasks, and on January 1st, 2022 for all other purposes.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 263 is 21 in favor, 0 against. Bill having received a constitutional majority is declared passed. Order the assembly.
Senate Bill number 269, introduced by Senators Keffer and Seaver-Scantz. It revises provisions relating to dental insurance. People of the state of Nevada represented in the Senate and Assembly do enact as follows. Section 1 to Section 1.
Thank you. Are there any amendments to the bill as a whole?
There are none. Section 17, this act becomes effective July 1, 2021. End of bill.
Thank you. Remarks from the floor. Senator Keffer.
Thank you, Madam President. Senate Bill 269 requires certain health insurers who provide dental coverage, including state and local government employer-based plans, to provide a written notice to a dentist of any attempt to recover an overpayment other than a duplicate payment. The bill also requires dental insurers to establish written procedures allowing a dentist to challenge an attempt to recover an overpayment. Dental insurers are prohibited from attempting to recover an overpayment more than 12 months after the date of the overpayment, except in certain circumstances. The bill also prohibits certain dental insurers, including state and local governmental employer-based plans, from refusing to pay a claim for which pre-authorization was granted, except in certain circumstances. The bill is effective on July 1st, 2021.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 269 is 21 in favor, 0 against. Bill having received a constitutional majority is declared passed. Order the assembly.
Senate Bill number 275, introduced by Senator Harris, revises provisions relating to communicable diseases. The people of the state of Nevada represented in the Senate and Assembly do enact as follows. Section 1 to Section 1.
Thank you. Are there any amendments to the bill as a whole?
There are none. Section 25, this act becomes effective upon passage and approval. End of bill.
Thank you. Remarks from the floor. Senator Harris.
Thank you, President. This bill does quite a few things. It makes some various changes related to communicable diseases. Among other things, the bill requires any order issued by the state or local health authority to isolate, quarantine, or treat a person or group of people with a communicable disease in an infectious state, or to people exposed to such a disease, to state the reasons the actions prescribed in the order are the least restrictive means to prevent, suppress, or control the disease. Prohibits a court from issuing an order necessary for a health authority to order involuntary treatment without clear and convincing evidence that the person has a communicable disease in an infectious state and is likely to pose a danger for the public. It repeals provisions making it a Category B felony for a person who tested positive for human immunodeficiency virus to intentionally, knowingly, or willfully engage in conduct in a manner that is intended or likely to transmit the disease. Such a person will be guilty of a misdemeanor under certain circumstances. It requires legislative counsel, to the extent practical, to ensure that people with HIV are referred to using language commonly viewed as respectful, and to avoid duplicate references to HIV and acquired immunodeficiency syndrome in the Nevada revised statutes, and provides it is the policy of the state to use similar references in the Nevada Administrative Code. It repeals various provisions of existing law relating to HIV and people with HIV. It reestablishes the Advisory Task Force on HIV Exposure Modernization for the 2021-2022 legislative interim. In summation, this bill goes through our Nevada revised statutes, tries its best to remove the stigma that has been placed into law around HIV and those living with HIV, and takes a small step forward to treating this more as the public health crisis that it is and not a crime. Thank you, President.
Thank you. Further remarks, Senator Kiefer.
Thank you, Madam President. I continue to have some concerns about the scope of this bill, particularly as it relates to the authority of public health districts to control communicable disease outbreaks. We're in the middle of a pandemic. We've been forced into situations with isolation and quarantine, and I worry about some of the restrictions in this bill and how they may relate to future response to outbreaks and pandemics. But the intent of the bill to decriminalize and destigmatize HIV infection, I think, is incredibly important. These stigmas are a disincentive to getting tested for people, which enhances the spread of the disease. And I think what we can do to remove that stigma and remove that criminalization is important. So at this point, I'll be supporting the bill and hope that it gets some attention on the more communicable disease breadth across the aisle. Thank you.
Thank you. Further remarks, Senator Hardy.
Thank you, Madam President. I thoroughly support this. This bill is going to modernize and bring up to date our understanding of HIV, and I am appreciative of the sponsor bringing this. I think it will go a long way towards helping people realize what they can do and what they can't do and how they can be appropriately accountable. Thank you.
Thank you. Further remarks? All right, hearing none, the Secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the Secretary will close the roll. The vote on Senate Bill 275 is 21 in favor, 0 against. The bill having received a constitutional majority is declared passed. Order to the Assembly.
Senate Bill number 288, introduced by Senator Harris, revises provisions relating to transportation network companies. People of the State of Nevada represented in the Senate Assembly do enact as follows. Section 1 of Section 1.
Thank you. Are there any amendments to the bill?
I have amendment number 484, proposed by the Senate Committee on Growth and Infrastructure.
Thank you. Senator Harris.
Thank you, President. I move that we dispense with the reading of the amendment.
Thank you. If there are no objections, so ordered. Senator Harris.
Thank you, President. I move that we adopt Amendment 484 to Senate Bill 288.
Thank you. You have heard the motion. Are there any remarks? Senator Harris.
Thank you, President. The amendment replaces the old bill with new language that results in 3 major changes in the approach, but no substantive changes to the overall result of the original bill. It, 1, allows TNCs to enter into agreements with MAV providers, autonomous vehicle providers, to make the TNC's digital network or software application available to connect passengers with the MAV provider. It amends Chapter 706A relating to TNCs by extending provisions applicable to TNC drivers to provisions of MAVs, including insurance coverage requirements, and it clarifies that the bill does not apply to autonomous vehicle network companies and their fully autonomous vehicles, which are licensed by the Nevada Transportation Authority under Chapter 706B of the NRS.
Thank you. Further remarks? All right, hearing none. All those in favor signify by saying yea. Opposed, nay. Motion carried. Are there any further amendments to the bill?
There are none.
Thank you. Bill, ready for final action.
Senate Bill number 288, introduced by Senator Harris, revises provisions relating to transportation network companies. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows: Section 1 through Section 24. This act becomes effective July 1, 2021. Into bill.
Thank you. Are there any remarks? Senator Harris.
Thank you, President. Senate Bill 288 authorizes providers of monitored autonomous vehicles to enter into contracts with transportation network companies to receive connections to potential passengers and related services for a fee in the same way that a driver enters into an agreement with the TNC. A monitored autonomous vehicle is defined as an autonomous vehicle with a safety engineer in the vehicle at all times when it is in operation. The measure adds monitored autonomous vehicle provider to the provisions applicable to a driver, including but not limited to passenger services, inspections, insurance, accident reports, and record-keeping requirements. A MAV provider must disclose the license plate of the vehicle to a passenger, but not the driver's license of the safety engineer. The TNC must also include information on providers of MAVs in its report to the Nevada Transportation Authority. The measure clarifies that the provisions relating to MAVs do not apply to fully autonomous vehicles or autonomous vehicle network companies which have been permitted by the Nevada Transportation Authority.
Thank you. Further remarks? Senator Pickard.
Thank you, Madam President. I just wanted to add, first to applaud my colleague for bringing the bill. And I appreciate all of the effort that went into getting it where it is today. I just want to make sure it's clear on the record that the safety engineer identified in the bill, and this was testified to in the committee, but want to make sure it's on the record that for all purposes of accidents and recovery, the safety engineer is considered, my understanding is the safety engineer is considered the driver for purposes of resolving any motor vehicle accident. Thank you.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 288 is 21 in favor, 0 against. Bill having received a constitutional majority is declared passed. Order to the Assembly.
Senate Bill number 289, introduced by Senator Harris, revises provisions relating to workers' compensation. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows: Section 1 to Section 1.
Thank you. Are there any amendments to the bill?
I have amendment number 408, proposed by Senate Committee on Commerce and Labor.
Thank you. Senator Spearman.
Thank you, Madam President. Move to dispense with the reading of the amendment.
Thank you. If there are no objections, so ordered. Senator Spearman.
Thank you, Madam President. Move to adopt Amendment 408 to Senate Bill 289.
Thank you. You've heard the motion. Are there any remarks? Senator Spearman.
The amendment provides certain provisions concerning an apportionment of percentages of disabilities where evidence of a previous impairment is present. Adds new sections to the bill to allow a physician assistant or advanced practicing registered nurse to file a claim for compensation for an industrial injury or occupational disease, and to allow a claim for compensation to be signed with the original or electronic signature of the injured employee and the treating health care provider. Amend sections 2, 4, 6, and 10 to include that, if requested, an insurer may provide to a claimant certain documentation by electronic transmission, the proof of sending and receipt of which is readily verifiable. Amend section 5 to prescribe the cost that may be awarded to the claimant and to provide that the certain information must be provided to a claimant within 15 calendar days. Amend Section 7 to provide that an insurer shall commence making installment payments to an injured employee not later than the applicable dates specified in this section as applicable. Amend Section 8 to retain the provisions proposed to be eliminated and provides that a claimant who elects to receive a lump sum does not waive certain rights, and amend Section 9 to require the insurer to include at least 3 vocational rehabilitational counselors who are employed by separate organizations.
Thank you. Further remarks? All right, hearing none. All those in favor signify by saying yea. Opposed, nay. Motion carried. Are there any further amendments to the bill?
There are none.
Thank you. Bill, ready? Final action.
Senate Bill number 289, introduced by Senator Harris, revises provisions relating to workers' compensation. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows: Section 1 through Section 12. This act becomes effective upon passage and approval. End of bill.
Thank you. Are there any remarks? Senator Harris.
Thank you, President. Senate Bill 289 revises various provisions concerning workers' compensation. The bill prohibits an apportionment of percentages of disabilities where no rating evaluation was performed for the previous disability unless the insurer proves by a preponderance of the evidence that medical documentation supports a specific percentage of previous disability or there is physical evidence of a prior surgery. The bill also requires an insurer to commence making installment payments to an injured employee within a specific period of time and without requiring the employee to elect a method of payment for that portion of an award of compensation for permanent partial disability, which is not in dispute. The bill further requires an insurer to send its determination by facsimile or electronic transmission to a claimant if requested and allows the claimant to toll a hearing if the insurer fails to send a determination regarding a claim for compensation. In addition, the bill authorizes a physician assistant or an advanced practice registered nurse to examine a patient for the purpose of ascertaining the character and extent of an injury and to file a claim for compensation for an industrial injury or occupational disease. A claim for compensation may be signed with the original or electronic signature of the injured employee and the treating healthcare provider. Further, the bill authorizes a person's compensation payable or paid for an industrial injury or occupational disease is subject to attorney's lien.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 289 is 21 in favor, 0 against. The bill, having received a constitutional majority, is declared passed. Order the Assembly.
Senate Bill number 303, introduced by Senators Brooks and Spearman, revises provisions relating to professions of people of the state of Nevada represented in the Senate Assembly. Do enact as follows. Section 1 of Section 1.
Thank you. Are there any amendments to the bill?
I have amendment number 226, proposed by Senate Committee on Growth and Infrastructure.
Thank you. Senator Harris.
Thank you, President. I move that we dispense with the reading of the amendment.
Thank you. If there are no objections, so ordered. Senator Harris.
Thank you, President. I move to adopt Amendment 226 to Senate Bill 303.
Thank you. You've heard the motion. Are there any remarks? Senator Harris.
Thank you, President. The amendment makes seven major changes. 1, it adds definitions of key terms. 2, revises provisions relating to advertising for residential solar panel systems. 3, authorizes instead of requires the State Contractors Board to adopt certain regulations. 4, removes provisions relating to certain loans or financing. 5, removes language regarding specific punitive actions and substitutes a reference to existing punitive actions that may be taken by the State Contractors Board. 6, adds consumer protection provisions that must be included in a contract, including disclosure of the retail price of a kilowatt hour and any offsetting tariff, and adds references to Chapter 598 in recognition of the overlapping jurisdiction of the Bureau of Consumer Protection in the Office of the Attorney General.
Thank you. Further remarks? All right, hearing none. All those in favor signify by saying yea. Opposed, nay. Motion carried. Are there any further amendments to the bill?
There are none.
Thank you. Bill, ready for final action.
Senate Bill number 303, introduced by Senators Brooks and Spearman, revises provisions relating to professions of people of the state of Nevada represented in the Senate Assembly. Do enact as follows. Section 1 through Section 17, subsection 2. End of bill.
Thank you. Any remarks? Senator Spearman. Nope. Remarks? Senator Brooks.
Thank you, Madam President. Senate Bill 303 provides for the regulation by the State Contractors Board of contractors who install residential photovoltaic systems used to produce electricity and includes responsibilities of a contractor who installs a residential photovoltaic system, required components of a written contract for such an installation, consumers' rights, authorization for the adoption of certain regulations by the State Contractors Board, involvement of the Public Utilities Commission of Nevada, restrictions on advertising and solicitations, and a requirement for the State Contractors Board to adopt further regulations on advertising, conditions under which such contracts are deemed unenforceable or void, applicability of statutes related to deceptive trade practices and enforcement by the Office of the Attorney General, and enforcement authorities of the State Contractors Board. This bill is effective on October 1st, 2021.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 303 is 21 in favor, 0 against. Bill having received a constitutional majority is declared passed. Order the Assembly.
Senate Bill number 320, introduced by Senator Neal, enacts various provisions relating to food delivery service platforms. People of the state of Nevada represented in the Senate Assembly. Do enact as follows. Section 1 of Section 1.
Thank you. Are there any amendments to the bill?
I have amendment number 406, proposed by the Senate Committee on Commerce and Labor.
Thank you. Senator Spearman.
Thank you, Madam President. Move to dispense with the reading of the amendment.
Thank you. If there are no objections, so ordered. Senator Spearman.
Thank you, Madam President. Move to adopt Amendment 406 to Senate Bill 320.
Thank you. You've heard the motion. Are there any remarks? Senator Spearman.
Amendment 406 makes 8 changes to Senate Bill 320. It provides the meaning of, quote, food dispensing establishment does not include a grocery or convenience store, clarifies that a food delivery service platform must enter into a written agreement with the food dispensing establishment, provides that the food delivery service platform is required to remove the food dispensing establishment within 48 hours after receipt of a request for removal, provides the platform must disclose in a statement the commission expressed as a percentage of the aggregate food purchase price by the provider for the food dispensing establishment, provides that if provided, the receipt must disclose certain information concerning the price of the order and any gratuity in plain language and in a conspicuous manner. It deletes certain provisions that set forth the manner in which the commissions are required to be disclosed. It amends Section 17 to replace the term commissions with the information required, and it prohibits a food delivery service platform from charging a food dispensing establishment a commission for an online food order that exceeds 20% of the food purchase price, plus a credit card processing fee. However, a food dispensing establishment may agree in writing to pay a platform provider a commission that exceeds 20% of the food purchase price to obtain certain optional products or services.
Thank you. Further remarks? All right, hearing none. All those in favor signify by saying aye. Opposed, nay. Motion carried. Are there any further amendments to the bill?
There are none.
Thank you. Bill, ready for final action.
Senate Bill number 320, introduced by Senator Neal, enacts various provisions relating to food delivery service platforms. People State of Nevada, represented in the Senate Assembly, do enact as follows: Section 1 through Section 19, subsection 4, and a bill.
Thank you. Remarks from the floor. Senator Neal.
Thank you, Madam President. Senate Bill 320 requires a food delivery service platform provider to enter into a written agreement with the food dispensing establishment before facilitating an online food order or using the establishment's likeness, registered trademark, or intellectual property. A food dispensing establishment may at any time submit a written request for removal from the food delivery service platform. A food delivery service platform must disclose to a user in a conspicuous manner certain information associated with the online food order, as well as on the receipt provided for an online food order. A person who knowingly violates this requirement to disclose certain information is deemed to have committed a deceptive trade practice. The bill also provides the food delivery service platform that violates certain provisions is subject to a penalty of $500. In addition, the bill authorizes the food dispensing establishment to bring an action if their likeness, registered trademark, or intellectual property was used in violation of the prohibition. Finally, during the period in which the declaration of emergency for COVID is in effect, food delivery service platform is prohibited from charging a food dispensing establishment fee or combination of fees for an online food order that exceeds 20% of the food purchase price unless the establishment agrees.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, Secretary will close the roll. The vote on Senate Bill 320 is 21 in favor, 0 against. The bill, having received a constitutional majority, is declared passed. Order the Assembly.
Senate Bill number 329, introduced by Senators Lang and Doniate, revises provisions relating to competition in healthcare markets. People State of Nevada, represented in the Senate Assembly, do enact as follows: Section 1, Section 1.
Are there any amendments to the bill?
I have amendment number 447, proposed by Senate Committee on Health and Human Services.
Thank you. Senator Ratty.
Thank you. President, I move to dispense with the reading of the amendment.
Thank you. If there are no objections, so ordered. Senator Ratty.
I move to adopt Amendment 447 to Senate Bill 329.
Thank you. You've heard the motion. Are there any remarks? Senator Ratty.
This amendment requires hospitals to notify the Department of Health and Human Services of a merger, acquisition, or joint venture with any entity. Requires physician group practices to notify the department of similar transactions involving the practice if certain conditions are met. Deletes sections 2 through 20 of the bill. and prohibits healthcare providers and facilities from entering into, offering to enter into, or soliciting contracts that prohibit a third-party insurer from steering a covered person to certain healthcare providers or placing them in tiers, or place certain other restrictions on the insurer.
Thank you. Further remarks? All right, hearing none. All those in favor signify by saying yea. Opposed, nay. Motion carried. Are there any further amendments to the bill?
There are none.
Bills ready for final action.
Senate Bill number 329, introduced by Senators Lang and Donate, revises provisions relating to competition in healthcare markets. People state of Nevada, represented in the Senate Assembly, do enact as follows: Section 1 through Section 22, subsection 2, end of bill.
Thank you. Are there any remarks? Senator Lang.
Thank you, Madam President. Senate Bill 329 requires hospitals and certain physician group practices to notify the Department of Health and Human Services of any merger, acquisition, or similar transaction in which they are involved. The department must post the information contained in such notices on the internet and publish an annual report based on the information. In addition, the bill prohibits healthcare providers, including healthcare facilities, from entering into, offering to enter into, or soliciting a contract that prohibits a third-party insurer from steering covered persons to certain healthcare providers or placing healthcare providers into tiers, or place certain other restrictions on the insurer. Healthcare providers or insurers who violate these provisions are subject to a civil penalty and are guilty of a Category D felony. Finally, the bill authorizes the Attorney General to use certain fees to investigate prohibited contracting practices. This measure is effective upon passage and approval for the purpose of adopting regulations and performing other administrative tasks, and on October 1st, 2021, for all other purposes.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 329 is 12 in favor, 9 against. The bill having received a constitutional majority is declared passed. Order to the Assembly.
Senate Bill number 354, introduced by Senate Committee on Education, revises provisions relating to education of the people of the state of Nevada, represented in the Senate Assembly, do enact as follows: Section 1 of Section 1.
Thank you. Are there any amendments to the bill as a whole?
There are none. Section 14, subsection 2, end of bill.
Thank you. Remarks from the floor. Senator Dennis.
Thank you, Madam President. Senate Bill 354 requires Nevada's Department of Education to develop a statewide framework for restorative justice. Restorative justice plans developed by school districts must align with the statewide framework and must include input from pupils. Furthermore, the policy developed by NDE to provide a safe and respectful learning environment must include requirements and methods for restorative discipline practices aligned with the statewide framework. The measure modifies procedures relating to suspension or removal from school by requiring a plan of action based on restorative justice to be provided before the suspension or removal of a student may occur. Additionally, SB 354 requires a school to offer certain services to a pupil who is temporarily removed from school. The bill makes various changes to statutes relating to suspension, expulsion, and removal from school to recognize students who are homeless, in foster care, or unaccompanied, and provides that a student may not be expelled or suspended from school unless it has been determined that the behavior of the pupil was not caused by homelessness or being in foster care. The bill requires NDE to include data in the statewide system of accountability, recognizing public schools that reduce the frequency of suspensions, expulsions, or removal of students from school. Finally, SB 354 requires discipline data collected by public schools to be disaggregated by certain subgroups of pupil and types of offenses, and to the extent possible under federal law, be posted on the school's website. The bill is effective upon passage and approval for purposes of adopting regulations and performing other administrative tasks on July 1st, 2022, for all other purposes.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 354 is 16 in favor, 5 against. The bill having received a constitutional majority is declared passed. Order to the Assembly.
Senate Bill number 369, introduced by Senate Committee on Judiciary, revises provisions relating to criminal procedures. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows: Section 1 of Section 1.
Thank you. Are there any amendments to the bill as a whole?
There are none. Section 6, subsection 6, end of bill.
Thank you. Remarks from the floor. Senator Scheibel. Senator Orenshaw.
Thank you, President. Senate Bill 369 revises statutes regarding the imposition of bail or other conditions of release to comport with the Nevada Constitution. The bill removes provisions requiring an arrested person to show good cause in order to be released without bail. Additionally, the bill consolidates existing procedures for releasing a person with or without bail into a standard procedure for courts to follow in making pretrial custody determinations. A court must only impose bail or a condition of release, or both, on a person if it deems doing so to be the least restrictive means necessary to protect the safety of the community and ensure that the person will appear at all times and places ordered by the court. A prosecuting attorney may request bail, but must prove by clear and convincing evidence why it is necessary to protect the community and ensure that the accused person will appear. Finally, if a person used a firearm in committing the act for which the person was arrested, there is a rebuttable presumption that the least restrictive means necessary to secure the community's safety and ensure the person will appear in court includes the imposition of bail or a condition of release, or both.
Thank you. Further remarks, Senator Settlemyre.
Thank you, Madam President. When hearing the bill, the concept that bothers me is the removing of the requirement that an arrested person show good cause before being released without bail. I think it's important that before someone be released, they do show good cause. And during the testimony, some of the opposition indicated that this bill will lead to criminals being released who will then further harm their victims of sexual assault. And for those reasons, I oppose this bill. Thank you.
Thank you. Further remarks, Senator Cannizzaro.
Thank you, Madam President. And I did want to note that the language that had previously been that had been included within the NRS provisions regarding release of bail, and specifically the phrase of without cause, was actually something that was struck down by the Supreme Court as being unconstitutional. And so while that phrase, I agree that when we think of good cause, that seems very innocuous and something that shouldn't be an issue to provide. It was something that did fall, at least with respect to Senate Bill 369, within the purview of the Supreme Court's finding of the unconstitutionality of that particular phrase and requiring a defendant who is being held to show good cause prior to being able to set bail. I'm appreciative of this bill because I do think that it balances the Supreme Court's decision in the Valdez-Jimenez case, but it also does so with some additional considerations for instances wherein someone is committing an offense with the use of a firearm. I think those cases are much more serious and should be taken more seriously and show a demonstrable enough evidence that that person poses a danger to the community that we should be considering things like bail and other conditions of release to keep the community safe where a firearm is involved. And so I think that this bill strikes a balance in protecting the community and providing some additional safeguards, while at the same time recognizing the Supreme Court's decision in the Valdez-Jimenez case and aligning our statutes with their constitutional findings in that case, and would urge my colleagues' support. Thank you, Madam President.
Thank you. Further remarks? All right, hearing none, the Secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the Secretary will close the roll. The vote on Senate Bill 369 is 17 in favor, 4 against. The bill having received a constitutional majority is declared passed. Order of the Assembly.
Senate Bill number 381, introduced by Senator Committee on Commerce and Labor, revises provisions relating to certain businesses. The people of the state of Nevada, represented in the Senate and Assembly, do enact as follows. Section 1 to Section 1.
Thank you. Are there any amendments to the bill?
I have amendment number 480, proposed by Senator Don Darrell Loop.
Thank you. Senator Dondero Loop.
Thank you, Madam President. I move to dispense with the reading of the amendment.
Thank you. If there are no objections, so ordered. Senator Dondero Loop.
I move to adopt Amendment 480 to Senate Bill 381.
Thank you. You've heard the motion. Are there any remarks? Senator Dondero Loop.
This amendment deletes Section 1 concerning exemptions from licensure and regulation as a deferred deposit, high interest, or payday lender, or as an installment lender.
Thank you. Further remarks? All right, hearing none. All those in favor signify by saying yea. Opposed, nay. Motion carried. Are there any further amendments to the bill?
There are none.
Thank you. The bill ready for final action.
Senate Bill number 381, introduced by Senate Committee on Commerce and Labor, revises provisions relating to service contracts. The people of the state of Nevada, represented in the Senate and Assembly, do enact as follows. Section 1 through Section 18, subsection 2, end of bill.
Thank you. Any remarks? Senator Dondero-Lu?
Thank you, Madam President. Senate Bill 381 revises various provisions governing providers of service contracts who issue or sell a home service contract. Among other things, the bill increases the initial and renewal fees from $1,300 to $2,600 and requires that a provider of service contracts renew a certificate of registration biennially instead of annually. Provides certain requirements relating to claims for services for a provider who has issued or sold a home service contract. Prohibits certain practices concerning settling or denying a claim for services by providers of home service contracts, codifies existing regulations and statute which require a provider to refund the unearned purchase price of a service contract to a holder who requests the cancellation of the service contract in accordance with the terms of the contract, establishes the definition of an emergency service contract, and requires the service contract provider to disclose whether a home service contract is or is not an emergency service contract, and provides that the sale of a service contract to a consumer or third party does not constitute the business of insurance for the purposes of federal law. This bill is effective October 1st, 2021.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 381 is 21 in favor, 0 against. Bill having received a constitutional majority is declared passed. Order of the Assembly.
Senate Bill number 389, introduced by Senator Neal, establishes provisions governing peer-to-peer car sharing programs. People of the State of Nevada represented in the Senate Assembly do next as follows. Section 1 to Section 1.
Thank you. Are there any amendments to the bill?
Amendment number 391, proposed by Senate Committee on Revenue and Economic Development.
Thank you. Senator Neal.
Madam President, I move to dispense with the reading of amendment number 391.
Thank you. If there are no objections, so ordered. Senator Neal.
I move that the Senate adopt amendment number 391 to Senate Bill 389.
Thank you. You have heard the motion. Are there any remarks? Senator Neal.
Yes. As Amendment 391 establishes that a peer-to-peer car sharing program is required to collect on the total amount for which the vehicle will share through the program the governmental service fee of 10% plus any additional fee imposed by authorized counties that is currently imposed on the short-term rental of vehicles. It requires a peer-to-peer car sharing program to enter into an agreement with the Department of Taxation for the purposes of collecting sales and use taxes under certain circumstances. It requires the money received from the fees collected by the peer-to-peer sharing program to be distributed in the same manner as the proceeds from the short-term rental of vehicles, which requires the proceeds from the 10% fee to be deposited into the state general fund and the distribution and use of the proceeds from the county fees to be identical to the current short-term rental vehicle proceeds.
Thank you. Further remarks? All right, hearing none. All those in favor signify by saying yea. Opposed, nay. Motion carried. Are there any further amendments to the bill?
There are none.
Thank you. Senator Brooks.
Thank you, Madam President. I move that we re-refer Senate Bill 389 to Senate Finance.
Thank you. You have heard the motion. All those in favor signify by saying yea. Opposed, nay. Motion carries.
Senate Bill 391, introduced by Senate Committee on Health and Human Services, revises provisions relating to dentistry. The people of the State of Nevada represented in the Senate Assembly do enact as follows. Section 1 to Section 1.
Thank you. Are there any amendments to the bill?
There are none. Section 49, subsection 2, end of bill. This bill requires a two-thirds majority vote.
Thank you. Remarks from the floor. Senator Ratty.
Thank you, President. Senate Bill 391 makes various changes related to dentistry. It provides that the state dental health officer is not required to be licensed to practice dentistry in the state if certain other criteria are met. It removes a prohibition on the state public health dental hygienist pursuing an outside business or vocation, instead authorizing such activity with the approval of the Division of Public and Behavioral Health of the Department of Health and Human Services. In addition, the bill authorizes the Board of Dental Examiners to issue a limited license as a dentist or dental hygienist to the state dental health officer or state public health dental hygienist. Senate Bill 391 also authorizes the division to issue a permit as a dental responder to a dentist, dental hygienist, a dental therapist who has received certain training in emergency response. Dental responders may provide emergency medical care, immunizations, medical care in mobile clinics, and humanitarian care during a state of emergency, declaration of disaster, public health emergency, or other event. The bill creates the Committee on Dental Emergency Management within the division, and it prescribes duties of the committee which relate to emergency management and the practice of professions that provide dental care. And finally, SB 391 outlines requirements related to providing services through teledentistry and requires hospitals and Medicaid managed care plans or health maintenance organizations to take certain measures to improve access to oral health care through teledentistry. It's effective upon passage and approval for the purposes of adopting regulations, hiring staff, performing other preparatory tasks, and on January 1st, 2022 for all other purposes. This bill came out of the Interim Committee on Healthcare and came from some learnings during the pandemic specific to the emergency responder pieces, that this is a healthcare workforce that we can use in more effective ways during a disaster if we build some infrastructure around that. It also seeks to do some of the work on teledentistry that we've done on telehealth generally. And finally, it makes sure that we have the positions that we need in the state in the dental health officer and the dental hygienist organized in a way that we can recruit good candidates and keep good candidates. Thank you.
Thank you. Further remarks, Senator Settlemeyer.
Thank you, Madam President. I think the bill does a lot of great things. I think this bill was discussed that it would actually allow dentists to give COVID shots and things of that nature potentially, or maybe I have it confused with another bill. But one of the questions that just came up in my mind, are we stating that the person who's going to be in charge of all the licensed dentists in the state of Nevada doesn't themselves have to be licensed in the state of Nevada?
Thank you. Senator Ratty.
Thank you. Thank you for the question. So to the first question about immunizations, there was another bill moving through the legislature that I'm not sure where it ended up that would allow dentists to do immunizations broadly. This bill limits that to only in a state of emergency. So that's an important distinction. And then with regard to the licensing, this actually matches up how we license the chief dental health officer to the same exact way that we do the chief medical officer for the state. And so it allows a provisional license, recognizing that they actually typically don't practice medicine every day. And so then that does broaden the recruitment. So they would be trained as a dentist. They would have probably had experience as a dentist, but as they move into this role, they might be coming out of academia. They might be coming out of some other place where they've let their practice license expire, but could do the provisional license that's outlined in the bill. But it does match it up to my understanding of how we do the chief medical officer now.
Thank you, Senator Settlemeyer. All right, further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 391 is 21 in favor, 0 against. The bill having received a 2/3 majority is declared passed. Order of the Assembly.
Senate Bill number 397, introduced by Senate Committee on Health and Human Services, revises provisions relating to certain persons who remain in foster care beyond the age of 18 years. The people of the state of Nevada represented in the Senate Assembly do enact as follows, Section 1 to Section 1.
Thank you. Are there any amendments to the bill?
I have amendment number 285 proposed by Senate Committee on Health and Human Services.
Thank you. Senator Ratty.
President, I move to dispense with the reading of the amendment.
Thank you. If there are no objections, so ordered. Senator Ratty.
Thank you. I move to adopt Amendment 285 to Senate Bill 397.
Thank you. You have heard the motion. Are there any remarks? Senator Ratty.
Amendment 285 to Senate Bill 397 requires the Division of Child and Family Services within the Department of Health and Human Services to establish and administer the Extended Young Adult Support Services Program to provide extended support services to certain young adults between 18 and 21 years of age whose plan for permanent placement was on their 18th birthday a permanent living arrangement other than reunification with their parents. It revises terminology so that such individuals are referred to as young adults rather than children, revises certain processes and procedures related to the program, including eligibility criteria, information that must be provided to young adults regarding participation in the program, court processes and jurisdictions, and termination of participation, and requires the division to submit an annual report regarding the program.
Thank you. Further remarks? All right, hearing none. All those in favor signify by saying yea. Opposed, nay. Motion carried. Are there any further amendments to the bill?
There are none.
Thank you. Senator Brooks.
Thank you, Madam President. I move that we re-refer Senate Bill 397 to Senate Finance.
Thank you. You have heard the motion. All those in favor signify by saying yea. Opposed, nay. Motion carries.
Senate Bill number 408, introduced by Senate Committee on Finance, revises provisions relating to the State Board of Pharmacy. The people of the state of Nevada represented in the Senate Assembly do enact as follows, Section 1 to Section 1.
Thank you. Are there any amendments to the bill as a whole?
There are none. Section 15, subsection 2, end of bill. This bill requires a 2/3 majority vote.
Thank you. Remarks from the floor. Senator Spearman.
Thank you, Madam President. Senate Bill 408 makes various changes to provisions governing the State Board of Pharmacy. Among other things, the bill authorizes the board to enter into certain written agreements and contracts. It revises the credentials authorizing a person to manufacture, engage in wholesale distribution of, compound, sell, or dispense any drug, poison, medicine, or chemical. Increases from $500 to $1,000 the maximum fee that may be charged for the investigation, issuance, or renewal of a license to a manufacturer or wholesaler. Requires an applicant for registration as a pharmacist or a pharmaceutical technician to undergo a criminal background check, and makes it a misdemeanor to secure or attempt to secure any certificate, license, or permit issued by the board through false representation or fraudulently represent oneself to be the holder of such a certificate, license, or permit. The bill is effective upon passage and approval for the purpose of adopting regulations and performing preparatory administration tasks on July 1, 2021, for all other purposes.
Thank you. Further remarks? All right, hearing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on Senate Bill 408 is 21 in favor, 0 against. The bill, having received a 2/3 majority, is declared passed. Order the Assembly.
Senate Bill number 57, introduced by Senate Committee on Government Affairs, revises provisions governing the imposition of certain special assessments by a board of county commissioners or a governing body of a city. The people of the state of Nevada, represented in the Senate Assembly, do enact as follows. Section 1 to Section 1.
Thank you. Are there any amendments to the bill as a whole?
There are none. Section 5, subsection 7, end of bill.
Thank you. Remarks from the floor. Senator Dondero-Loop.
I move to dispense with the reading of the amendment.
I don't know that we have an amendment. Senator Dondero-Loop, did you want to just go to remarks?
Okay. I will do that. That piece of paper will go away. Senate Bill 57 authorizes a Board of County Commissioners or a governing body of a city to recover an unpaid fine or fee for an offense relating to real property by making it a special assessment against the real property, which may be collected in the same manner as ordinary county taxes. The bill also eliminates the requirement that 180 days or 12 months, as applicable, have elapsed for a special assessment to be imposed. And last but not least, the bill is effective October 1st, 2021.
Thank you. Further remarks. Senator Orenshall.
Thank you, President. I rise in support of Senate Bill 57. I appreciate all the hard work that Clark County and the other local governments have put into this, reaching out to the stakeholders, to legal aid. Short-term rentals are a big problem in my part of the state. I voted yes in committee. I reserved my right on the floor. I still have some concerns about the bill and whether maybe the net's a little too broad here in terms of folks who might have code violations and don't have the physical ability or the financial resources to come into compliance. But I know there's a commitment from the proponents of the bill to try to work on some of my concerns and some other concerns over in the other house. So I will be supporting and urge its passage.
Thank you. Senator Hammond.
Thank you, President. I've gone down this road before in the past when we're talking about liens and fines, and my concern with the bill is the increasing the ability of counties to collect any fines or penalties as taxes may have massive implications in the lending industry. And while collecting some items this way is currently allowed, it is limited to nuisance and health and safety issues, which are shared concerns with the lending community. Broadening this collection authority to include all fines and penalties means a nearly unlimited expansion of risk for lenders and the investors that fund the loans. Clark County, for example, has provided or has provisions prohibiting short-term rentals, the fines for which can run into the tens of thousands of dollars and even into six figures. Fannie Mae, Freddie Mac, and Ginnie Mae, the GSEs, collectively account for well over 90% of all residential mortgages. All three have taken strong positions against a similar proposal known as PACE, which is known as Property Assessed Clean Energy. These entities will not purchase loans made with PACE financing in front of the mortgage. I believe that all three entities will take a similar position with this expansion of collection authority. Short-term rental properties, as an example, are not consistent with already allowed provisions relating to the usability and safety of the property, nor do the actions they seek to remedy improve the property in any way as PACE would. Given the history of strong protective measures taken by Fannie and Freddie in the past, I strongly believe that expanding county collection rights beyond the existing narrowly defined categories will cause the GSEs to cease purchasing mortgage loans originating in Nevada. One can only imagine the catastrophic damage that might cause, and for that reason, I can't support it at this time.
Thank you. Further remarks? All right, seeing none, the secretary will open the roll. All right, looks like everyone's voted. Does anyone wish to change his or her vote? All right, the secretary will close the roll. The vote on SB 57 is 12 in favor, 9 against. The bill, having received a constitutional majority, is declared passed. Order from the assembly.
That concludes order of business number 13 and business of the desk for this legislative day.
All right, order of business 16, remarks from the floor. Doing. All right, Senator Cannizzaro.
Thank you, Madam President. I again wanted to extend my sincere thanks, and I'm sure the thanks of my colleagues in this building, for our wonderful and amazing staff for being patient enough to allow us the time to discuss legislation we've been voting out, and for being here and working so hard and late into the evening for the last couple of days. We truly appreciate having you and couldn't do this without each and every one of you, so thank you again for all of your hard work. With that, Madam President, yes, I think very much. And with that, Madam President, I would move that the Senate stand in adjournment until the hour of 11 a.m. on Wednesday, April 21st, 2021.
Thank you. You heard the motion. All those in favor signify by saying yay. Opposed, nay. Motion carries. See you tomorrow, guys.